Sham, in this video we're going to be considering joint and several liability under the new umbrella company legislation from April 2026 as it pertains to people working through their own personal service companies, or PSCs, I understand.
The joint and several liability, obviously it's a new concept, and it's going to apply to different contractual chains in probably different ways. And so it's important to try and dissect each of those contractual chains to see how the new legislation is going to fit with real life situations, really. And so this video we're going to look at how the legislation is going to apply to that particular scenario, particularly when there's either the end client directly engaging a PSC or even longer contractual chains where there's agencies and umbrella companies and any other party that you can think of between the end client and the PSC. As you know, PSCs, they're quite a complex area already because there's a number of different deeming provisions that could apply to that situation where an individual is supplying their services through their own limited company. Now, generally, when we look at PSCs, everybody starts to think about IR35 as the biggest problem, which it is, and has always been the case for the last 25 odd years. And that legislation has seen a change over the last few years, which has made different parties responsible for particular bits of tax that might apply to PSCs. And to simplify or complicate it even more, we've now got some joint and several liability that could potentially apply alongside or separately to the IR35 piece of legislation.
Okay, so IR35 is still staying?
It is still staying,
away.
Yes, it's not going away, and it's still staying in both forms. So if you've got a small end client, the IR35 responsibility remains with the PSC. If you've got a medium or large client, or a public sector client, or a public body, as it's set out in the legislation, then it's that end client that has the initial liability for IR35.
Okay.
And I think everybody in the sector probably is aware that those changes have been in place for a few years, although we still come across the odd situation where it still lands as new. And that generally is when end clients have shifted from being small to being medium and large. And that's where it kind of takes those clients by surprise every now and then.
Okay, so how does this new legislation change things?
It changes things because the liability under IR35, where an end client can pass it down the chain, all they have to do is issue what we call a status determination statement. So that's the end client concluding whether IR35 applies or not to a particular PSC. And if it applies, the further parties down the chain should operate PAYE on the payments to that limited company. If it doesn't apply, the PSC can continue to engage as it has been over the years. Now, the problem with contractual chains and PSCs, it's often the case that certain parties might not be aware that there's PSCs in the chain. And this is where perhaps the revenue has started to see a bit of lost revenue, because if the end client doesn't know, SDSCs are not issued, then that money essentially flows through the chain without anybody knowing. So to try and get other parties to be more responsible with this, joint and several liability could well come into this on the basis that, well, if there's a perception that the money paid to the individual should have been earnings, then the joint and several liability can kick in to try and capture that.
Okay, so what's the test under this new legislation? When does joint and several liability actually apply?
So, well, obviously, as in our earlier videos or the other videos that we've had, we've talked about the protective part of the legislation and then the targeted part of the legislation. Now, given the complexity of the targeted part and the purported umbrella company aspect, I think it might be useful just to have a quick explanation of how the protective part may impact it, but we can say that it definitely doesn't and why it doesn't. And I think that's important because then we get on to the purported umbrella company bit, and to have an understanding of the first part will certainly help understanding the second part.
Okay.
So in order for the protective part of the legislation to apply, all we have to have is an individual providing their services to a client, and that person is employed by a third party, the umbrella company. And in that umbrella company, the individual cannot have a material interest. And that's one of the conditions for the umbrella company definition within the joint and several liability legislation. So with PSCs, an individual will almost always have a material interest of 5%, generally. Generally it's 100%, but the minimum is 5. So any more than 5, and the entity in which that individual has that material interest would be a personal service company. So we can say that the protective part of the legislation can't apply here because the individual has a material interest in that umbrella company.
So a PSC can't be an umbrella company because the individual owns 5% or more.
Yes.
In essence, yeah.
In essence, yes. So if it can't be an umbrella company by that definition, we then have to go down, as you termed it, down the rabbit hole of purported umbrella companies. And as we know, there's 3 different cases of purported umbrella companies, or what could be a purported umbrella company. There's perhaps only 2 that are relevant to this.
Okay.
And so what we can say is case 2 is most certainly out of the equation, because that applies to self-employed individuals providing their services to a client via a party in which they don't have a material interest.
Right.
So we can say case 2 is definitely out.
Okay.
The next, I guess, most relevant one would be case 3, because that is specific to individuals that have a material interest in the umbrella company. So we can say most definitely that that's the one that was perhaps targeted towards limited companies in which the individual has a material interest, so PSCs.
Okay, Shem, so from what you're saying, a PSC can be a purported umbrella company under case 3 of the purported umbrella company bit of the legislation. What are the conditions for that to apply?
Well, essentially, there's only one condition, which is that the individual, or the starting condition is one condition, that the individual has a minimum of 5% material interest in that company. And if it does, then we've used the term already before, we're going to go down the rabbit hole, because all we're looking at then is that the revenue reasonably suppose that somebody in the contractual chain or involved in the arrangements, a party in the arrangements, would have assumed that the substantial proportion of the monies paid to the individual would have been paid as earnings.
Okay.
It's an either statement. So it's either that applies, or that the limited company or the entity in which the individual has that 5% material interest has given the impression that that is the case, that they are receiving those monies as earnings. And essentially that's all that's required in order for case 3 to apply.
Okay, so if I'm understanding this correctly, to summarise, if the client thinks PAYE is being operated and there's a PSC at the end of the supply chain, but it turns out it's not, the money's been taken out as dividends, which would be typical with a PSC, that makes it a purported umbrella company. And then what are the consequences of that?
Yeah, so the consequences are that it does actually invent a new deeming provision, and the consequences are such that the purported umbrella company is essentially the employer of that individual, and the monies paid should be treated as earnings. And if it hasn't been, that's where the joint and several liability kicks in, and it makes the purported umbrella company, therefore the PSC, and either the end client or the party that has the contract with the end client liable for any PAYE that the purported umbrella company hasn't paid.
So how would you summarise this part of the legislation, Cham?
Well, one, it's complicated. So I think the key thing is to review your supply chains. Where you see that there are PSCs involved, you need to start to think about whether any one of these case 3 or case 1 could potentially apply. If they do, the key thing is that if the individual owns more than 5% in the limited company, you've got to be careful that JSL may potentially apply to that particular engagement.
So Sham, other than case 3, purported umbrella company that you've just outlined for us, is there any other way that a PSC could be caught up in this legislation?
There is, I mean, it might be an unintended consequence of this piece of legislation, but case one could also possibly apply. And we think that it could apply in cases where perhaps the end client is unaware that there's PSCs in the chain. So it's almost oblivious to the actual factual nature of that contractual chain. And if they are under the impression that the individual is actually employed by either the agency or some other party in which that individual doesn't have a material interest, then it could just be the case that case one applies. And all that's needed for that is for the revenue to reasonably suppose that one of those parties in the chain thought that the individual was employed by another party in the chain. And if that's the case, then case one would apply. Of course, it switches around who's liable for what, but certainly a PSC could well be impacted by case one as well.
Okay.